Afternoon, everyone. On behalf of the Brazilian IP Association, we welcome you all to the webinar, IP System in Americas during the COVID-19. Thank you very much for joining us this afternoon. As you might already know, we provided simultaneous translation to Portuguese, and at the bottom of your screen, there is an icon like a globe, and all you have to do is to click and choose the language you prefer. At the end of the webinar, we will open for questions, and we ask you to do it through our live chat. Thank you again. We now pass on to our moderator this afternoon, Mr. Valdir Rocha. Mr. Valdir Rocha is a Brazilian IP attorney, head of the IP practice group of Veirano Advogados since 1990, Secretary General of ABPI, member of ABPI, INTA, AIPPI, IBA, and GALA, and co-author of 28 books on trademarks, advertising, cyber law, and franchising. Thank you, Valdir.
Thank you, Erica. Hello, everybody. We are speaking today in English because we have an audience from the Americas, including the US, the Caribbean, and Latin America in general. So we have representatives of 6 countries here. I'm going to introduce first of all, I'd like to say that ABPI, the Brazilian IP Association, is honored to host this webinar with so many important leaders of the IP community in the continent. And we have a partnership with each of these associations, with AIPLA, with AMPPI from Mexico, AAPI from Argentina, ACHIPI from Chile. So this cooperation agreement we have is not only for academic purposes, but also to exchange information and ideas. So this is one of the results of this cooperation agreement. And we're going to start with the host, Luiz Edgard Montaury Pimenta, president of ABPI. He's a Brazilian lawyer, senior partner of the IP firm Montaury Pimenta Machado in Vieira de Mello. And he's the current president, has been re-elected president of the Brazilian IP Association, and he's also a member of several IP associations. So, Luiz, you have the floor.
Thank you, Valdir, and thank you, Uri, on behalf of AIPLA, and on behalf of Bárbara Fiaco. Thank you, Eryck, Juan, and Rodrigo for all joining our webinar today. As Valdir said, it is a pleasure for ABPI to have you all here. And I will start about what the Brazilian PTO has been doing during this COVID-19 situation down here. I will try to mention bullet points and comment on some of them because we don't have too much time. And so far, things are going quite well in Brazil. The Brazilian PTO has adopted the home office system for all the examiners, all the employees. And it's working quite well since they started doing that. They suspended for different, from time to time, all deadlines. The last suspension ended on May 31st. So all the deadlines start running again on July 1st. So we have now all deadlines running and everybody's working electronically. And the home office for the examiners and the staff has been extended until August 16. This has been published today at the Brazilian official gazette. So this is new for all of us in Brazil. All the meetings with the examiners have also been suspended, and we don't know when they will be reactivating those meetings at the Brazilian PTO to talk to the examiners. Another important point is that the examiners, they are working quite well from home. As a matter of fact, they are doing more at home than they used to do at the Brazilian PTO. So their rates of examinations are higher than before, which is good for all of us. This is the official information. In practice, at least on the trademark side, what we are seeing is that less decisions have been published in the official gazette. A lot of decisions just shelving applications and with no merits decisions. But they are doing a good work, and the systems are working well. So we are very thankful for what they are doing because it's working well. The number of filings at the Brazilian PTO during this period has also declined. We have 12% less trademark applications being filed in Brazil, and 20% less patent applications being filed in Brazil. So what refers to the trademark applications, maybe we have something to add on that, which is because Brazilian joined the Madrid Protocol about 6-7 months, maybe more, 8 months ago. So maybe this will be a reflect from the Madrid Protocol filings in Brazil. So nowadays we have about 5,500 trademark files filed in Brazil through the Madrid Protocol system. 1,400 coming from the US, 1,000 and almost 200 coming from Europe, 450 coming from China, 175 coming from Japan, and 120 coming from South Korea. So these are the basic numbers we have regarding the Madrid Protocol that really affects the number of filings through the regular channels. So, but the official information is that 12%, there is a 12% decline on the number of trademark filings in Brazil during the Corona-19 period. So in what refers to patents, it's important to mention that the Brazilian PTO has adopted a priority examination system for patent applications related to the COVID-19, not only devices, but vaccines, medicines, process. So nowadays we have almost 100 patent applications being examined under this priority examination program. So this was something interesting that the Brazilian PTO has been doing, and they were very fast to put in place a system like this. And they have put in place also some additional programs, such as that we call in Portuguese, Observatório. The Observatório program is a program implemented by the Brazilian PTO to promote innovation regarding everything related to the COVID-19. gathering all available information in the COVID area. And this program is daily updated. All information they can obtain regarding innovation on the COVID program is being published in the Brazilian PTO website at the Observatório icon that they have over there. They have one person dedicated exclusively for this program, making all the researches and getting all the information available worldwide regarding what could be helpful for the COVID. So another important issue to tell is that not only ABPI, but ABPI is doing a lot, but all other local associations, we are organizing and promoting a series of webinars, podcasts, lives, web talks with the board of the Brazilian PTO, with the examiners, with directors of patents, of trademarks, in order to enable them to connect with the users of the IP system in Brazil, to connect with the IP, to the ABPI members, in order to let them know what they are doing, how things are going, or what can be improved. So they have been very friendly and open to suggestions and to our participation in the programs they are about to establish. Regarding new legislations in Brazil about COVID, basically what is interesting to inform here is that there are several new proposed bills for new laws for that compulsory license. We have that provision in our law, patent law already. So ABPI took an official position and sent this position to the House of Representatives, informing that there's no need to have new legislation on that, because we have one already in place that could accommodate any issue related to the compulsory license. And regarding the Brazilian courts, they never stopped. Just the deadlines, they have been suspended in different courts, different ways and periods of suspension of deadlines. But they are, the judges and the staff, they are working quite well. And a lot of decisions have been issued. And again, as the Brazilian PTO, in the opinion of several of the users of the court systems in Brazil, are very happy because they are producing and deciding a lot at home. All the judges are working from home, issuing decisions, and all the hearings, court hearings, and presentations at the Court of Appeals have been made through Zoom and other app systems. So all the attorneys are normally appearing in court to defend their clients using those apps and presenting oral arguments, as we have been doing in the past at the courts. But now, again, it's all virtual. So we are quite happy with those systems in court, in all courts. The problem is that some courts have suspended for different periods than the others, state courts, federal courts. So this was something not so easy to deal with, because we have always to pay a lot of attention in which court is suspending for what time the deadline. So this was not an easy task because Brazil is a huge country, different states, different state courts, and we have to deal with all of that. In order to move with the other presentations, I would like to announce that ABPI will soon officially be announcing an award program called Patent of the Year in the COVID-19 area. And the winner will be announced during our annual Congress, which will be held on October next. And we are about to decide if the Congress will be all virtual or mixed virtual with presence for some panels. We are still discussing that. And again, this will also be announced soon. So thank you for listening to what's going on in Brazil. And I pass the word to Valdir Rocha again.
Thank you, Luiz. We now go to Yuri Fisher, representing the American IP Law Association, AIPLA. He's a co-chair of AIPLA IP Practice in Latin America Committee. He's a founding partner of Lawton Fisher, who dedicates his practice to patent and trademark procurement and intellectual property litigation. Yuri has represented a diverse group of US and foreign-based clients in patent, trademark, copyright, and computer law litigation matters. And prior to commencing his legal career in 1996, Yuri was employed as a chief of engineering by a Florida-based independent aeronautical engineering firm. So Yuri, if you can try to cover US in 10 minutes, it's gonna be tough, but let's try it. Thank you.
Thank you, Valdir. I appreciate it. And thank you to ABPI for having me speak. I'll try to cover it in 10 minutes. The basic things that I want to cover is what the USPTO has done so far to assist applicants in the trademark and patent fields to meet deadlines, really, in view of the COVID-19 emergency. And in this respect, the USPTO has been very, very responsive, very active. They have issued a number of notices and they have issued a number of extensions. But as the situation has somewhat normalized, these deadlines and these measures are really coming to an end pretty soon. So it's important that people understand what is still in effect and what is going to be ending and what they have to do in order to comply with some of these requirements. So, like I said, the USPTO has issued a number of notices with regard to extensions. They've issued 4 notices. The most recent one was actually yesterday. And rather than go through all the extensions that they granted, I want to just go through what is currently in place today and what is ending shortly. So, and with respect to patent prosecution, in big part, what is still in place in response to COVID-19 depends on whether you are a small entity or a large entity. As most people know, under the USPTO practice, a company, generally speaking, a company over 500 employees will be considered a large entity, and all other applicants and some additional applicants like universities and nonprofits would be considered small entities, or individuals who have meet certain requirements are also considered micro entities, which are even smaller. So right now, the USPTO has in place what is an extension. They're not issuing suspensions, but they're basically saying any deadline that falls between March 27th and July 1st of this year has been automatically extended until July 1st. So these extensions have been ongoing for quite some time, but they are now coming to an end. So if you have an extension, be aware that that extension is only going to run until July 1st. So you better make plans to respond to anything that's pending. And this applies to things like office actions, payment of almost all fees, most appeal deadlines, and these extensions are available without the filing of any extra petitions. The only thing the USPTO requires is that you file a statement stating that any delay is caused by COVID-19, and they provide a form with the required language. So you basically have to do is sign it. And my understanding is that the USPTO is going to be quite liberal in allowing these. For the most part, if you sign the statement, they're going to allow the extension. The following deadlines have also been extended through September 29th, and these are basically inception fees, issue fees, and maintenance fees. But again, only for small and micro entities. Large entities, none of these apply. And these are basically basic filing fees, national fees for national stage applications under the PCT, issue fees, and maintenance fees. Again, these are going to be extended through September 29th, but all other extension expired as of July 1st. Now, if you're a large entity, none of these things apply to you, but the USPTO has in place some measures that can provide some relief. So they have the usual extensions of time that are normally available for up to 5 months or 3 months, depending on the nature of the extension, and those are still available. In addition, if your application becomes abandoned because a deadline expired between March 27th and July 31st, you are entitled to file a petition to revive, which you normally are. But in this case, if you file a petition to revive, the USPTO will waive the fees, which can be quite substantial. I believe the current fee for a petition to revive is $2,000 for a large entity. So having waived it, it's a big relief for these entities. And again, my understanding is that the USPTO is going to be quite liberal in granting these extensions, and they're not going to submit into a lot of scrutiny because they understand the situation. Now, be aware that if you have to file a petition to revive, there are some negative consequences. Primarily, you will have to file a terminal disclaimer. So any period of time during which the application was technically banned is going to be reduced at the end of your patent term. So if you had 20 years and you had to suspend for 3 months, you're going to get three months less of patent term. In addition, it is possible in the US that somebody down the road may question whether a delay was actually caused by COVID-19. And of course, we don't know what's going to happen with that. I assume the courts are going to be pretty lenient on that, but there's never telling what's going to happen. So although these things are available, we would encourage anybody who has a pending US patent application that if you can file a response in time, that you do so without resorting to these things. In addition, some other measures have been taken by the USPTO to allow for priority rights to be extended. Usually you get 2 months under most international treaties. You get 2 months for claiming priority to US provisional applications. You still get those 2 months. They have passed some resolutions which allow the extension to extend for an additional 1 month. And in addition, they have waived the fees for some of these filings, which as the revival fees can be quite expensive. So this can provide a lot of relief for anybody who has to file a national stage application, or for somebody who has a provisional application and has to extend the time to file a non-provisional, or for somebody who's applying in the US pursuant to the Paris Convention and has the 12-month period coming up for expiration. You're going to be able to get an extra month in addition to the usual 2 months, and you're not going to have to pay the very, very high additional fees for some of these petitions. It's worth noting that all these deadlines right now are set to expire on July 31st, and the last notice that the USPTO issued yesterday indicates that they are not planning at this moment to issue any further extensions. So, like I said, this is really coming to an end at this point. So if you have applications pending in the US and the patent side, you better get moving and find out a plan for getting them caught up as far as delays caused by COVID. The USPTO is open. All the offices are open. Most of the business these days is done electronically anyways and by telephone. but my understanding is that they're still receiving paper filings if you want to file them by hand. You can set up interviews with examiners by doing it by phone or by video as you could before. So pretty much it's business as usual for the U.S. Patent and Trademark Office. It's business as usual for most law firms in the States. Most people like firms in Latin America are operating remotely, but pretty much everybody is open, everybody's doing business. So that should not really cause much of a delay. The only thing that really is causing delay right now is sort of the financial concerns. Most businesses are closed, and so the PTO is helping by extending the payment of fees. On the trademark side, there were some extensions initially granted, but everything that's an extension under the trademarks ended as of May 31st. So the usual deadlines are now in place. And in connection with the PTAB and the TTAB, which are the administrative actions within the Patent and Trademark Office, those, again, initially had some automatic extensions, but now are really proceeding on an as-needed basis. So it's if you need an extension, if you're in an extenuating circumstance, you can apply for it. You will usually get an extension, but you have to do it on a case-by-case basis. Finally, I want to close with saying that the USPTO, like Luis was saying in Brazil, the USPTO has launched some programs allowing for accelerated examination of both trademarks and patents that are related in any way to COVID-19. They will be automatically placed at the front of the line, and you will not have to pay any additional fee to accelerate the cases. So it's a good development. I have no statistics showing what has been filed to date, but I'm sure some of these applications will be issuing shortly. And you know, finally, I don't have any statistics about whether the number of patent applications or trademarks has been reduced, but I would expect, seeing some of the informal statistics and my own personal experience, I would expect something on the same lines that Luis commented about Brazil, something around 10%, probably decrease. So I don't expect it to be a major impact, but there is certainly going to be some impact with what has been filed and what is going to be filed. So that is the view from the U.S. Again, thank you so much for having me, and if there's any questions, I'm happy to answer.
Thank you, Yuri. As a housekeeping note, if the audience has a question, they can use the chat space to ask the questions, either in Portuguese or English, because we have interpreters, and we can translate to our friends as well. Next, from Mexico, Eryck Castillo, representing ABPI. Eryck Castillo is a Mexican lawyer, a senior partner at Uthoff, Gomez, Vega, and Uthoff, with more than 30 years of experience in intellectual property, current president of the Mexican group of ABPI, which is ABPI, and member of committees of INTA, ABPI, and ACTA. So Eryck, tell us about Mexico in 10 minutes, please.
Thank you very much, Valdir. Thank you to everybody. Well, I would love that the news concerning Mexico were so favorable as the ones that we have heard from Uri and Luis, Brazil and the United States. Today we are celebrating 100 days since the Mexican Trademark Office and the Mexican Copyright Office closed. They closed on March the 23rd. So it's been 100 days in which we have been receiving some notices of they are partially opening. They were completely closed on March the 23rd. So what happened is that after that day, there was a lot of pressure from the Mexican Association of IP and of other people that wanted to get protection. So this pressure helped, especially at the Mexican Patent and Trademark Office. So they slowly began to reopen some of the activities that they have. So nowadays, all deadlines are suspended. They are still suspended, and we don't have a fixed date on which they're going to be opening, like you have in the United States that Uri was mentioning on July the 21st, July the 1st, etc. So we don't have an exact deadline. There are some rumors that they are going to be opening on July the 13th, But what has happened is that when the Mexican Patent and Trademark Office and the Mexican Copyright Office decided to close, what happened is that they served the first notice saying, okay, we go after the Holy Week, so we open Monday, April the 13th. And then they extended that to May the 4th, and then they extended that to June the 1st. So it has been like that. We have just been waiting until when they're gonna be opening, because the pandemic has been slowly increasing in Mexico, especially in Mexico City, where these offices are located. So what they decided to do is that they stick to a traffic light that is managed by our health authorities, where red means that all activities have to be suspended. Then you have orange, yellow, and green. So nowadays, Mexico City yesterday moved from red to orange. So the Trademark Office, the Copyright Office, and the Special Chamber of the IP, the Special IP Chamber of the Federal Court, they are all located here in Mexico City. So they are now in orange. But until they get to yellow is when we presume that they're going to be opening to the general public, which should happen on July the 13th, according to the information we have from the government. So what happens is that the Trademark Office, what they decided to do, the Patent and Trademark Office, what they decided to do is during this period of time of these more than 3 months, they were not ready. Well, we should begin with that. They were not ready to work from home. They were not ready to do everything electronically. Some things like filing of trademark applications could be done electronically since a couple of years ago, but most of the actions could not take place electronically. So they decided to invest a lot on that, and they opened during this span of 3 months the possibility to file all kinds of trademark and patent applications, designs, models, etc. So this was opened in this era, these 3 months. Also, they decided to open this electronic window in order that all matters related to trademark maintenance, such as renewals, declarations of use, changes, assignments, etc., all of these actions could also take place electronically. So that's also good news from the Mexican Patent and Trademark Office. Another thing that they did a couple of weeks ago was that they opened the possibility to convert all patent applications that were previously filed in paper. According to law, if you filed it in paper, you need to continue the prosecution in paper. If you filed it electronically, you could, or you needed to continue electronically. So what they did is that they opened the possibility to convert all patent applications that were filed on paper to do it electronically. So it was done like, I think like 2 or 3 weeks ago. What has happened is that you need to pay a fee, which is around $20, more or less, a government fee to do this conversion. So this has not been very attractive to big corporations that have a big number of patent applications pending, because they don't want to spend that $20 and perhaps a really minimal attorney fee to do all these steps and do the conversion, and they prefer to keep their applications still on paper. I would love to give you some statistics, as Luis was mentioning, but my contacts at the Mexican Patent and Trademark Office have conveyed that since all deadlines are suspended and they are not yet uploading all the information at their database, that have the statistics of how many trademark applications have been filed in the past 3 months, or how many patent applications, or how many oppositions, or how many answers to official actions. So all of these, unfortunately, is something that I cannot give you at this moment, but I expect that once they resume activities, hopefully within the next 2 weeks, we should have that information available on our website. Another important thing is that all the authorities at the Mexican Patent and Trademark Office and at the Copyright Office are working from home. So even though the deadlines are suspended and the authorities are not yet notifying any official action, any resolution. They are not yet doing anything of that. We know that the personnel is working from home. So when they open to the public, they will not begin from zero. So they will already have studied a lot of cases, and we will be receiving a lot of official letters with the examination procedure of, let's say, a renewal application or a trademark application, or maybe an answer that was provided in February to the prosecution of a patent application. So all of this work being done on home, but yet we don't know how they're gonna be notifying to us all of these resolutions. Another thing that is important is that Monday of last week, June the 22nd, the Patent and Trademark Office decided to open their premises for contentious proceedings. So we had been putting a lot of pressure to the authorities at the PTO, saying, okay, you have opened the access for patent applications, for trademark applications, but what about litigation? So what they said is that they were going to be opening this special table or chamber directly at the Mexican Patent and Trademark Office. So you had to schedule an appointment, and with this scheduled appointment, you can go and you can file 3 cases at the same time. So they want to keep this. They don't want to have a lot of people getting there and being on the risk of being of getting the disease or getting COVID-19. So you need to have an appointment. You can only do it on a 3-case basis, and this has been helping a lot. This is the only statistic that I have. They say that since Monday of last week, they already have more than 300 appointments already scheduled for the next few days. So that's good, and at least some of the litigation procedures are moving on right now at the Mexican Patent and Trademark Office. The Copyright Office, the only thing that they did is that they had 2 addresses or email addresses open to the general public, so you could file some of the copyright work that is handled therein, but nothing more than that. You don't get any answer from them. You don't get any acknowledgement of receipt, other that they received the corresponding email. So it's not working as we would love that it would work. And the special IP chamber of the federal court is completely closed, or that depends entirely on the judicial system. So we don't know when they're going to be opening. We also expect that if the Mexican Trademark Office is opening on July 13th, we expect that we get some news during, I don't know, maybe today, tomorrow, or the day after tomorrow, giving some news about what's going to be occurring before the federal court. So during this period, what the Patent and Trademark Office has been doing is they have been answering a lot of questions that have been through their website, have been delivered. They are doing a lot of lessons. They implemented a new tool for trademark searches, etc. But the most important part, and which is the one that we were most interested, which was for the authorities to begin working from home and begin notifying or serving all the resolutions for applications. This has not yet occurred. So if eventually the Trademark Office decides to continue the suspension, well, the only thing is that we will keep pressuring the authorities so that they can begin and they can have the engine running, so that also, well, the activities of all the law firms and all the companies that are involved in IP, well, doesn't get hurt as it has been hurt during the past 3 months. So these are basically the news from Mexico. I would love to answer any questions that the audience may have eventually after the interventions from my colleagues from Argentina and Chile. Thank you very much.
Thank you, Eryck. We now have Juan Berton Moreno from Argentina. representing ABPI. Juan is an Argentinian lawyer, graduated from the Argentine Catholic University, UCA, a partner in Berton Moreno in Argentina, with more than 20 years of IP practice. Juan is a member of the board of ABPI and also member of committees of INTA, ACIPI, and ECTA. So Juan, please speak to us about the Argentinian situation, not only the PTO, but the courts as well.
Thank you very much, Valdir. It's a pleasure, and thanks also, Luiz Edgard, for the invitation from ABPI. First of all, as Eryck was saying, our situation, it's also, we're now in a lockdown with the COVID since now for 103 days. I think we are a record with the days of lockdown. The first resolution in Argentina was on March 18, was resolution 16/2020, suspending all legal and regulatory deadlines as well as summons office actions until April 3. Then there were many other extensions or suspensions of these deadlines by the Argentine Patent and Trademark Office. One was from June 8 to June 28, 2020. That was resolution 51/20. But the last one is from yesterday, resolution 69/20. It's so it extends all the suspensions of legal terms and deadlines from June 29 to July 17, 2020. As you can see, we were having a long lockdown and suspension of all deadlines and legal terms, even though the office, the Argentine Patent and Trademark Office, has established what it's called here, and since April 23, it's called the care customer service with minimum guards and shifts. You have to appoint by email and respect the sanitary restrictions, but you can even go there and have your appointment with all these restrictions. The Patent and Trademark Office is having all kind of electronic platforms. You can file trademark patents, even though in these forms nothing has stopped in this respect. And even though all the deadlines and legal terms are suspended, we expect the Patent and Trademark Office to be some kind of, let's say, that they have some kind of flexibility with analyzing their legal requirements or formal requirements and not be so strict with practitioners, because things are quite difficult in that respect. Other thing, and now regarding trademarks, is that our association, the Argentine Association, had a request with the Argentine Patent and Trademark Office regarding trademarks that were granted in less than 6 months, and the risk of vulnerability of the rights of those trademarks that were claiming priority of marks abroad. So the office answered us some days ago that the goal of the office is granting trademarks in 7 months, so as not to vulnerate the rights of those ones. Regarding publications of the trademarks, as you perhaps know, in Argentina, we have TM class since November 15, 2019. And the goal of the office, of the Trademark Office, is to study those applications one day after its presentation. But for those who do not fulfill those requirements or claim priority, they are expecting more or less, let's say, 30 days to study them. Regarding trademarks that are no TM class and that they are before November 15, 2019, they will need like 10 bulletins to publish them all. And after they update all the database, the goal is the following: for trademark applications that are TM class, to publish them within 15 days, and those that are not TM class, it will take them, what they tell us is approximately 60 days. Other issue that it's important, it's regarding patents. Patents, there was a publication of the patent bulletin 1091 on June 24, only last week, where they inform many decisions and background exams regarding patent applications. They are expecting to do these publications every week, even though the terms are suspended. What the patent office is trying to do in that regard is to begin to study those cases. Even though the terms are suspended, I think it's a good idea, and the patent office is working well with studying the cases. Another issue regarding patents that is quite important is we asked with the Argentine Association on June 25 to the patent office if they can grant in a digital format the patents. So, and the patent office answered us that they are willing to do so. They are studying the cases, and not only that, but also the priority documents. They are willing and will try to have them granted in digital format. They will begin, they are saying, with the patents granted on November 2019. There are many ways that as our association, the Argentine Association, is interacting with the Argentine Patent and Trademark Office. Even though we have the suspension of all these terms and these suspensions, we have quite a fluid channel, and they are responding a lot. They are very interactive with us, and we think it's we are having quite a. They are doing their work quite smoothly. Other thing that it's important, and that the agents were requesting, but this we couldn't make it, is that all the agent exams for 2019 and for 2020 they are suspended for the time, and also and one good thing is that the payment of the annual sworn declaration for the agents, it was extended up to September 30, 2020. So we have an extension. So the Patent and Trademark Office is taking into consideration these things. Finally, one thing that I want to say is that our association is doing, as well as ABPI. I was hearing Luis telling about that, some webinars with of different topics and putting in different practitioners, and we are doing a lot of things to keep all the agents informed of the situation of the IP in Argentina. Thanks very much.
Thank you, Juan. Now we go to Chile with Rodrigo Puchi, representing ACIPI. Rodrigo is a Chilean IP attorney, graduated from the University of Chile's Law School, and has a master's degree from the University of Alicante. He teaches commercial law at the University of Chile since '95, and is the current president of Chilean chapter of LES. He has written many papers on IP, and he speaks Portuguese, so he prefers to speak Portuguese to the Brazilian audience today, since we have a translator that will translate it to English. We didn't have a translator for Spanish, but so Rodrigo is going to speak Portuguese to us. Rodrigo, pode falar.
Okay, obrigado. Oh, thank you so much. I don't know what do you prefer, but I will make my best efforts in Portuguese. Obrigado por el convite, y solamente quería falar. Thank you for the invitation, because eu gostaria de começar a apresentação aqui dentro do Chile como um panorama. A ver, espera un poco porque estoy oyendo el translation.
You have to change the language to Portuguese down in this globe at the bottom of the screen.
¿Ya? ¿Ahora sí? Agora sim?
Muda o globo lá, a língua.
O que acontece aqui dentro do Chile é uma situação um pouco complexa. Eu não sei o que acontece, porque eu estou ouvindo também a pessoa que está fazendo a tradução.
Érica, pode explicar para ele em
It's
português?
because porque você tem que trocar a língua que está setada para português e não inglês. Senão,
Mariel, eu não sei o que acontece porque começo a falar e estou ouvindo a você, então não posso...
Rodrigo, embaixo da tela está escrito
Cancelar.
Portuguese or English, tem um globo. E você tem que setar português para não ouvir a tradução da Maíra.
Já, aí cancelei, já. Agora sim. Então, o que acontece dentro do Chile foi uma situação um pouco complexa. Por quê? O que aconteceu aqui quando o vírus do Covid chegou aqui dentro de Chile, muitas autoridades administrativas começaram a ditar normas em relação a Covid. Por exemplo, o INAPI dictou umas circulares ou resoluções onde eles suspenderam muitos prazos referidos a prazos fatales que a gente tinha dentro da oficina de marcas e patentes. A primeira resolução foi de abril, foi de março, e essa habilitou a suspender os prazos de processos administrativos desde dia de março até 30 de abril. Depois, essa mesma circular falou da possibilidade de postergar a suspensão de processos administrativos. Então, em geral, esse foi um tema bem abordado por INAPI, Oficina de Marcas e Patentes. Então, com isso, a situação foi normalizada. Mas, paralelamente, o Congresso começou a emitir certas leis para adaptar a situação à Covid. Então, eles ditaram uma lei onde eles disseram que o Poder Judiciário tem que dictar normas para adaptar a situação à Covid. O que aconteceu? O INAPI dictou uma lei, uma circular, por meio da qual eles têm que suspender audiências e vistas físicas e pessoais. Então, com isso, a autoridade pública que tem coberto dois frentes. Um, referidos a prazos fatales que tinham ou que caíam dentro do prazo legal, e outro permitiu que as pessoas já não foram mais ao INAPI. O INAPI, por outro lado, eles tinham já mais ou menos 1 ou 2 anos um projeto de trabalhar somente de maneira digital. Todos os processos dentro do INAPI, dentro da Autoridade Marcária de Patentes do Chile, tudo está digitalizado. Então, quando a gente começou a fazer teletrabalho dentro do Chile, a situação foi muito mais fácil. Por quê? Porque já estava toda a plataforma, todo o trabalho que a gente já estava fazendo, tudo estava em linha, online, e a gente podia apresentar online, tramitar, apresentar provas e coisas assim, tudo online. Então, quando chegou o Covid dentro do Chile, a situação foi muito mais fácil em termos que as pessoas podiam fazer muito melhor as apresentações, tudo. Então, temos esse como um princípio geral, que a situação dentro do Chile está bastante bem dentro de tudo. Um segundo ponto que eu gostaria de falar é as leis que ditaram o Poder Judiciário, porque, como estava falando, o Poder Judiciário falou que, a partir de agora, até que a situação mude, todas as audiências e tudo o que diga relação com coisas de propriedade industrial e também com outras audiências de Poder Judiciário em geral, vai ser feitas pelo teletrabalho. Então, tem muitas plataformas para que você possa fazer coisas tudo online. Ainda, você pode fazer alegações ante o Poder Judiciário de maneira virtual. Então, você pode tudo fazer videoconferências. Também, quando você tem alegações ante o Tribunal de Apelação de INAPI, também você pode fazer videoconferências. Então, agora a situação dentro do Chile está muito normalizada, e que posso dizer que, em geral, o sistema está funcionando bastante bem. Se aí tem uma norma que é muito importante dentro do Chile, que se alguma pessoa tem algum problema de não poder cumprir com algum prazo, uma vez que cesse o impedimento, a pessoa pode apresentar uma ação para restituir os prazos. Então, em geral, esse é o panorama legal e de Poder Judiciário, de INAPI e de propriedade industrial aqui em Chile. Un tercer punto que gostaria de falar es de lo que Luis falou, que aqui dentro de Chile eu não tenho as estatísticas perfeitas em relação a pedimentos de marcas, patentes, mas mais ou menos as marcas desceram, eu acho, o filing, mais ou menos 15%, mais ou menos. Mas patentes foi um pouco menor, de 10%. Mas, em geral, a situação aqui dentro de Chile está trabalhando bem, está, em geral, eu posso falar que tem muita boa colaboração entre o que é a parte privada e a parte pública. A CHIP, a Associação Chilena de Propriedade Industrial, onde eu sou um dos diretores, temos muita comunicação com a autoridade pública. Então, quando algum associado tem algum problema, geralmente a CHIP era a via idônea para poder conversar e falar com as autoridades. Outra coisa que gostaria de terminar falando é que também o INAPI agora tem alguns concursos para incentivar o desenvolvimento de invenções referidas à Covid. Então, também estão fazendo como, não um Patent of the Year como o Brasil, mas estão fazendo os melhores esforços para gerar um ambiente de invenções referidas à Covid. Porque ao final do dia, a Covid está afetando o mundo inteiro e a única forma que a gente pode trabalhar unidas, parte pública, parte privada, autoridades, investidores e todo mundo em geral, tratar de adaptar nossos próprios costumes com a nova realidade que aqui em Chile está falando como uma nova realidade a partir de agora que vai mudar tudo. Com isso, eu estou fechando que dentro do Chile, em geral, a situação está bastante bem, bastante desenvolvida e somente esperar que a nova normalidade já volte o mais pronto possível. Obrigado, Valdir.
Obrigado, Rodrigo. Vamos ver se temos perguntas. Eu identifico uma para o... I can see a question to Eryck. Can you read it, Eryck? Do you read it at the chat? Do you know, it comes from Gresley Marcano. Eryck, do you know whether the same thing will be done for trademarks? That is, the possibility of switching paper filing to electronic?
Yes, no, this has also occurred. So what happens is, I'm sorry that I did not mention that. When they opened first for trademarks to file everything, the second step was to permit also everything that was filed physically, you can now file it electronically. But different from patents is you do not need to do any kind of conversion. You do not need to file or to pay any kind of government fee. Rather, in this case, you only file it and the trademark office will accept it. And the following steps for the procedure of that application will be conducted electronically. So I hope that with this, the person in the audience gets a reply, but yeah, now everything for patents and trademarks can be done electronically if it was first done physically.
Thank you. We have, she's saying that yes, you answered.
Okay.
And we have just one comment, one salutation from João Marcelo Safin. I would like to greet everyone. I don't see any more questions on the chat, so but Luiz, go ahead.
Valdir, I would like to present a question to Eryck regarding, so in case of infringements in Mexico during this period, how the trademark owner or the patent owner could do to stop the infringement during this time?
Unfortunately, there is no, the question is, if you find someone is infringing your trademark or your patent, well, unfortunately, you cannot do anything right now. As of Monday of last week, if you were aware of that situation, you could file the corresponding infringement action. So beginning June the 22nd, this special table or chamber or office of the Mexican Patent and Trademark Office opened. So you got your appointment, you could file the corresponding infringement action. So the Trademark Office will now begin to study that. And it is uncertain really to know if they're gonna be studying this on a quick turnaround or not. but I presume that since they are going to be opening within the next 15 days, I presume that once they open, you will be able to request also some of these precautionary measures, like the stop of the sale of the products, payment of a bond, or etc. All these kind of measures to try to prevent the corresponding infringement.
Now I have a question to Yuri. Can you speak about the situation of the courts? We know that the busiest courts specializing in IP in the US are in New York, and if I'm not wrong, in California and DC. And New York was hit heavily by the pandemic. So what's the situation in the courts? Are they working online normally? Have the deadlines been suspended or extended?
For the most part, the federal courts are operating electronically and online. You know, as you know, most of the court proceedings are done on paper, but to the extent that there are hearings, depositions, trials, those are really going online, either by telephone or by Zoom. I'm not sure about actual trials. I know that in Florida, where I live, although the federal courts have not been holding trials yet, I know that state courts have been holding trials by Zoom. And, you know, there's been mixed results with that, but they've started to do it. The state courts down here are saying that they plan to resume trials probably by September or October of this year, but more realistically, it would start around January. So there's going to be quite a bit of a backlog of trial proceedings. And I imagine that, and I know for a fact that federal courts are going to be the same way, although they're probably going to resume trials sometimes in late this year or early next year. There's going to be quite a backlog. But the courts are open. You can file, you can argue, you can have hearings. I've had several since the last month or so. So it's from the attorney standpoint, other than trials, it's proceeding as normal.
Thank you. Now, since we don't have more questions from the audience, you can ask questions among yourselves. We have a few minutes. Juan, would you like to ask a question to someone? To another panelist?
Yes, why not? I was hearing what Rodrigo was saying. It's in some kind of way, sometimes with Chile, we have quite the same situation and the lockdown is quite long. Is it the online filing of trademarks and patents? Is it going smoothly, or do you have your problems there, Rodrigo?
Thank you, Juan. No, here in Chile, all the situation is working very well because, as I mentioned it previously, here in Chile, we had a normal situation with digitalization, and we used to use the system through the INAPI website, and this works very, very well. And even more nowadays, they are implementing that we can pay even the taxes that we have paid, that we need to pay sometimes electronically, because now they have some agreements with the banks. And nowadays, honestly, the situation is working very, very well. At the beginning, it was a little bit weird because, you know, when the lockdown began, everybody was a little bit afraid of what is going to happen. But nowadays, I am pretty sure that the situation is working very well. And I think that in the future, probably this will be the new normality that we used to stay here in Chile.
Thank you. Obrigado.
Okay. Eryck, do you have a question for any of the panelists?
Rather, I just want to make a comment. I'm seeing that most offices have at least developed some kind of work to do it electronically. Of course, some are really much more advanced than the Mexican patent and trademark office, like the US, Brazil, and Chile. No offense, dear Juan, but what really is interesting is I heard that there is this expedited procedure in the US and also in Brazil for things related to COVID. and this is something that I have not heard nothing at all before the Mexican patent and trademark office. So I'm just taking a note on this, and I'm gonna be requesting a comment from the general director of the Mexican patent and trademark office to see if we can do something similar to that. No, we do have these licenses, public licenses, like it occurs in many countries, but really, if a company has developed something and wants to get protection, well, it would be worth that it doesn't spend 3 years to get the patent application granted, etc., so they can have something expedited. So that's something that it's really helpful for me to know that it's occurring in Latin America and that we should replicate here in Mexico.
Thank you. Yuri, do you have a question to anybody? I think we have a few more minutes. Yuri, you have
No, I don't have any questions, but I do see that somebody else posted a new question to Rodrigo.
You're right. Lilia Rosales. A question to Rodrigo in Chile. The extensions of terms to file change in ownership documents has not been suspended? For trademarks, I mean. Rodrigo, para você a pergunta.
Okay. No, here in Chile, there was two kind of extensions, you know. First of all, refer just to administrative, and the second one referred to term from producing evidence, you know, these kind of things. In relation to your questions, if the INAPI has issued a deadline, nowadays, in the current situation, you have to comply with the deadline, unless you have an impediment that you cannot comply with this deadline. And then when this impediment has been removed, you have to allege this fact before the Chilean trademark office. So at the beginning, you have to comply with the deadline. If you have a problem, then you have to allege before the Chilean trademark office of these impediments, and then they will give you probably a new deadline. This is the situation more or less like we are working with.
Marcano.
No, I hear Rodrigo, sorry if I missed it. Our deadline still suspended? No, nowadays we don't have a suspended deadlines.
So, Luis, would you like to make your final remarks so we can close the webinar, please?
Yes, I would like to thank you all, good friends for a long time again. And this is very useful information for all of us, for me, for ABPI, for the ABPI members, and I hope to all the association members as well. And keep safe. And I hope this COVID-19 issue, the solution is found as soon as possible. And Brazil, we have been, the press is being advertising a lot that Brazil is developing the Fiocruz with the Brazilian health entity connected, is in a project with the Oxford University and AstraZeneca. They are testing in Brazil a new vaccine, and the World Health Organization keeps telling us that is the most advanced project regarding the cure for the COVID issue in the world. So we hope this will get the results as soon as possible. Do you have any other information on that, Valdir?
Oh, that's what I heard. The principles of the World Health Organization said that the most advanced project is the one between Oxford and the Brazilian government and Fiocruz. So, but there are 150 drug companies developing vaccines, but according to the World Health Organization, this is the project that is most advanced. So today in the paper, there was an article about Brazilians being tested already, volunteers. So we hope lots of drug companies come up with vaccines, and we are very hopeful with this project. So Liz, you can close, and Erica will put the video on.
Okay, so thank you again, and hope to see you in another event soon. And pass the words for Erica just to finish our webinar.
Thank you.
Thank you all for being here with us this afternoon. I hope to see you in our next meetings. We have them all in our website, abpi.org.br. And thank you again.
Thank you.
Bye,
Bye, everybody.
Thank you very much for the invitation.
Gracias
Ciao.
a todos.
Thank you so much. Bye. Chao, chao.